Should we begin? Okay, so we have read yesterday that how this sections and orders have to be read along with each other, and I hope that you have ultimate clarity on the point that these sections and orders are not required to be read separately, rather they are required to read conjointly. Not in disjunction, but in conjunction. I hope you remember this All India Radio. I hope you remember this PSC. I hope you remember that formula which I developed yesterday for you. I hope you remember how this suit process follows and how this journey takes place. I hope you remember all of them. So first lesson was that never read sections and orders in isolation, rather than read them in conjunction. आप जब भी धाराओं को और आदेशों को पढ़ेंगे तो उनको एक दूसरे के साथ पढ़ेंगे. ये पहली लेसन हमने आपको दी थी. और दूसरी लेसन जो है, जो लोग नए भी हैं उनको भी मैं बताना चाहूँगा कि यू शुड फोकस मोर ऑन आउटपुट देन ऑन इनपुट. आप बहुत ज़्यादा इन्फॉर्मेशन के प्रयास में नहीं रहेंगे. यू शुड नॉट सीक ऑल इन्फॉर्मेशन विच इज around you, rather you should concentrate on what you studied and whether you learned it exactly or not. That is what we call by output. So read, reread, study, deliberate, ponder over, think, teach, share, solve questions, and that is how you can learn better. Solving question is one of the biggest art of learning the idea or concept better. So till this time we have been doing overview of CPC and we have been learning the art of learning. But in further classes there will be more and more concepts. Now you have read this CPC little bit, survey can be done even further for your clarity and convenience. Is this clear? What I said, for your clarity and convenience, little bit more can be done. So be careful about that. Is this all right? There are 8 appendixes also, 8 appendix, A, B, C, D, E, F, G, H. And all other schedules. It is in first schedule, all other schedules are not there. They have been repealed, second, third, fourth, fifth. So we are left with only now this section 1 to 158 and order 1 to 51 and this 8 appendix. Is this clear? This is all right. This is all right. There are certain special factual information also which you can use for your memorization purpose. Is this clear? अब देखो बहुत सारे और भी तकनीक हैं, मैं आपको थोड़ा बहुत और बताता हूँ. Then I'll move further to process of CPC. Now when you read this CP Court, that is Civil Procedure Court, Act number 5 of 1908, which came into force on 1st January 1909. Many laws are applied after enactment and signature little later, because we want people to be acquainted with the law. Especially in IPC we did that. We signed this IPC in 1860, but enforced this IPC in 1862. So almost around 6th October it was signed by Governor General, but we applied it on 1st January 1862, so almost after 15 months. There is a reason behind that, that is a criminal law. So similarly in many other laws, because we want, this is civil law by the way, but we want people to be acquainted with law and then we enforce it. So this was enforced on 1st January 1909, and this is called the Code of Civil Procedure. Earlier it was not applicable to state of Jammu and Kashmir, but it is now not so, it is applicable there as well. So it extends to the whole of India except certain tribal areas. And why we do not invoke it to tribal areas, the reason is but obvious. Tribals have their own system of administering justice and enforcing law. So it is not considered proper and advisable to interfere in their traditional system, which they think that this is a kind of intervention. Is this all right? But these are not so important. Let us come to section 2 of this CPC, just for awareness. We are not reading section 2 right now. You must listen to me very, very carefully, because otherwise you will have confusion. We cannot understand right now decree unless we reach to the stage of decree. We cannot understand exactly order right now because we have not been able to reach to that stage. You cannot understand judgment particularly. You can read these words and you can memorize, cram them. And almost 99% or even 99.9% people are doing the same. They are not reading the law in proper context. And unless and until you understand the context, you cannot understand the text. Text always finds meaning in context. Text always finds meaning in context. And this context is very important. You cannot take a name and you cannot say that you understand this unless until you tell them all fact story around that name. So you will have to understand. If you introduce yourself to somebody that my name is this, so nobody knows what you are. So you are required to tell fact story around you, what you are. Is this clear? So similarly it applied in all laws. So you will have to be kind and patient. You cannot jump to every concept in every now and then. I cannot make you understand decree right now, because decree is not the stage which we are discussing right now. There is a stage in this civil procedure, we will understand it stage wise. That is what I say, context. And that is how we will find the meaning of text. So, but for little bit awareness, I cannot make you understand decree right now or order right now or judgment right now, but for your just convenience and awareness, because you may use certain words here and there. Like we are using this word again and again, plaint, suit, court, jurisdiction. We should have little bit awareness. We'll have awareness, but let us see what is written in section 2 just for your awareness, not for your understanding. Understanding and awareness are two different ideas. So I will be giving you awareness right now, not understanding of these terms written here. Understanding will come in proper context. So awareness and understanding, be careful. Now those who will join late, they will perhaps not appreciate, and then they will ask the question and then they will be really concerned that sir ne jawab nahi diya. So they do not understand the methodology. So that is why I request that you should be at the outset. You should not be like this, that the teacher will come then I will join. But most of you are joining after I am joining. You should be there before in the class, and this is what is our discipline and decorum. that you should be there in the class and then the teacher should come to the class, but you will understand it and appreciate it, I hope, little later, because this is a different era altogether. Everything is altogether now different today. Earlier we used to read grammar books very carefully because that will be very useful in understanding of law and writing of judgment and writing of plaint and writing of written statement and doing everything in law, because if you do not write correct grammar and correct usage is there, I don't think that you will be able to make impact in the mind of the other party or the other people or the judge, whatever it is, or the examiner. But in today's educational system, perhaps that is not being done so much, which was earlier there. So see how this CPC is written. I must have told you, and if I have not shared this idea with you, let me share again, that generally in all acts you'll find that in the beginning they give introduction and then they have a definitional clause, which is called legislative dictionary also. And in that legislative dictionary, what they do, they will explain you certain words. They will explain you certain words at the outset because they'll be using those words in the entire act. But as far as a students and teacher like we are concerned, we cannot have this luxury of understanding it beforehand, otherwise you will be wasting your enormous time and perhaps you may not understand. You may not understand contents of decree and is written in that order 20, rule 6, A, B, C, something like that, or 6, you will see it there. But that stage will come little late. It will take little bit time to reach to that stage. Still people are joining. I don't know why you are not in the class at the outset. You want teacher first, then you will join. This is what is now today's tradition, but this is not fair. You should be there before in the class, otherwise I will not be addressing you properly. You join it, then let me begin. So see section 2 by the way till that time. Now 2-1, this is court, it starts with court. So 2 plus 1, it is 3. C, third alphabet, 2-1 court. 2-2, decree. After C, this is written in alphabetical or dictionary order. 2 plus 2 equal to 4. D for decree. You can never forget this, that 2-2 is defining decree, and this will be an important question in your preliminary. And what is decree now? If you see this definition written, a decree is basically formal expression of an adjudication by a competent court. No. So formal expression for that you are required to see the appendix also. That is appendix D for decree. Formal, it has to be formal. No? Conclusively determine the right of the parties with regard to matters in controversy in suit, and maybe either preliminary or final. Now preliminary which decides matter at preliminary stage and preliminary issue is involved. Final, that is now you have decided that matter conclusively. It shall be deemed to include rejection of plaint. There is a reason behind including this as decree is always as appealable. So rejection of plaint is initiation of suit basically. So if plaint is rejected, your right is rejected. So if it is not appealable, then where will you go? You will not go to the higher court. So that is why rejection of plaint is made this decree, so that you can go in appeal always. Decree is always appealable. Order is not always appealable unless and until it is mentioned there in order 43. We will see that. And then it says after D, decree holder. So decree will be there, then only decree holder will be there. This is common sense. Or you pass the decree, then only decree holder. Now see, and then there is district. Now, if I have to memorize these words, because there will be in examination this kind of question where decree is defined, where code is defined. Not this is not so important. So where decree is defined, this is very, very important. This question has been asked many times. So I will give you a very simple formula that see this code begins with code. This is code, civil procedure code, so it begins with code. That is clear, 2-1 is code. Now follows D. After C there will be D. So there is 3 Ds. Decree, decree holder, district, 3 Ds. 3D picture देखते हैं ना, 3D movie. 3D movie you might have watched. 3D movie. So 3Ds. 3Ds. Is this clear? Decree, older district. Just giving you awareness. Then it says foreign. F for 5, F for foreign. F for 5, F for foreign. In both cases it is F. F for 5, F for foreign. Is this clear? F for 5, F for foreign. And thereafter foreign judgment. Foreign court and foreign judgment. Foreign judgment, you read that in 1314 also. Foreign judgment. Foreign judgment. So, and then after this 6, so 2, 1 you know, 2, C, 2, 2, 3, 2, 4, you know, 3Ds. Then 2, 5 foreign and 2, 6 also foreign. In first it is foreign court, in second it is foreign judgment. Foreign court, foreign judgment is used in CPC, section 13 and 14 I told you. So you are not required to force you to memorize all these things, you just see carefully that you can do it. This is code number 1. In this code we talk of decree, decree holder, and then there is question of district also, because now jurisdiction is decided on that basis, though district is not very important. Similarly 7 and 7A and 7B and 8 are not so important. 8 may be a little bit, but 7, 27, 27A and 27B. Now here it is written excluding state of Jammu and Kashmir. Now you will have to see it now carefully, because Jammu and Kashmir is integral part of India. So government pleader, 7A High Court and 7B India. In alphabetical order, I think this will come like this. So go or high, go high or G high, whatever. You can keep this in mind. So till 6 it is not an issue, 7, 7A and 7B are not important. They are not so important, they are not important. But you can keep them in mind little bit. Just have cool, calm patience and learn these small things very, very easily. Is this clear? So you just try to learn it very, very easily. It's very, very simple. Now, this is important. This 2, 8, 2, 9, 2, 10. 2, 8, 2, 9, 2, 10. This is important. This is all related to judgment. This is how you can make blocks to memorize things better. Judgment. Judgment. So judgment will be given by judge. So first judge, then judgment. This is how you can remember. And when judgment is given, then only you can talk of judgment debtor. When there will be judgment, then only judgment debtor will be there. So this is what we are required to inculcate. If you want to memorize things better, just now innovate these methods very. Judge will give judgment. And when there will be judgment, then there will be question of judgment debtor. So nobody can doubt this. Only thing which you can have in doubt is that in which provision, in which sub clause or where it is written. Where it is written. That confusion may be in your mind. So be careful. I tell you very simple rule, E Jo T. Everybody knows E is 5, J is 10, O is 15, T is 20 and Y is 25. Everybody knows this. So J is 10th. So there is 210 in which there is judgment. Now you know that there are three words related to judgment. Judge, judgment, judgment. That you keep in mind. Judge will give judgment, and when judgment will be given, then there will be judgment debtor. So you are required to keep in mind only this much. Judge, judgment, judgment debtor. This is what you are required to keep in mind. And only keep in mind this J is 10th alphabet. And this is the last one here. So obviously judgment debtor is towards the end. So 210. So judgment will be in 29. So judge will be in 28. This is how you can give guidance to yourself for better memorization and better understanding of the arrangement. Judge, judgment, judgment, debtor. 5 foreign, I said. So keep in mind the important words, not all. So till this point, out of 10 things which you have come to know, just a minute. Let me begin again. 2, 1, 2, 2, 2, 3, 2, 4, 2, 5, and 2, 6. Regarding this, I said C. This is code, civil procedure code. And then this is D, 3 Ds. So in 3 Ds, what were 3 words? Decree, decree holder. I am telling you where what is written and district. Now you just write it randomly and you just think which will come first, which will come second. D, E will come first. Then decree, decree. Then holder. So it will come after decree. And then first decree will be there, then only decree holder will be there. And district, DI. So DE, then only DI. This is very simple. You can remember this. I said foreign. F for 5, F for foreign. So there are 2 words. Court and judgment. You tell me which will come first, which will come second. So everybody knows this will come first. Then first the foreign court will be there, then foreign judgment will be there. Foreign court, then foreign judgment. Foreign court, then foreign judgment. So foreign court is first and foreign judgment is second. So this picture is clear to your mind? This should be clear to your mind, my dear friend. Now then, moving further, I said that the other words are not so important in 2.7 and 7a and 7b, they are not so important. They are not so important. Then 2.8, 2.9, 2.10. 10 is J, everybody knows, it is J. So J for judgment. J for judgment. We talk in procedural law of judgment. J for judgment. 10 is J alphabet. In English alphabet, it is 10th alphabet, J. So J is clear, judgment. So judgment, now judgment has 3 words. Judge, judgment and judgment debtor. So obviously, judgment debtor will come last, judgment will come second and judge will come first. There will be judge, then judgment, then only judgment debtor. So just try to appreciate this point. Judge, judgment and then judgment debtor. This is how you can keep in mind very simply, very logically. Nothing great. And here I said G high. G high. G is government, H is High Court and I is India. G high. Government pleader, I am talking of lawyers. And here I am talking of court. And here I am talking of territory. So government, High Court and India, but this is not important. This is important. This is important. Is this clear? Then let us move further. So till 10 you are clear. Till 10 you are clear. 11, 12, 13, 14, 15, 16. अब इसका भी फॉर्मूला है, सी 12, 13, 15, 16, 17, 11, no, 12 I said, 13, yes, 15, yes, 16, yes, 17 also. Now, this 212, 213, I'm not talking of 14 right now, 215, 216, 217. In all what is common, I tell you, in all there is P. P. M-N-O-P. O is 15th alphabet. P is 16th alphabet. 16th alphabet. So 16 में P होगा. That is how you can keep in mind. Then just above it, just below it, and then 212 and 213 also P. So these are 5 related, these are 5 P's. Only 14 I have left and 11 I have left. So 11 and 14 I have left. 11 and 14 I have left. Is this clear? Now these are all from P. So just see. 212 is profit. Which kind of profit? So it says mean profit. It is written M-E-S-N-E, but S is silent. Mean profit. Now see 13. Property. Which kind of property? Movable property. Movable property. 15 is pleader. 16th is prescribed. And 17 is public officer. This is what is dictionary. Mean, movable, pleader, prescribed, public. But these are all P related. Profit, property, pleader, prescribed, public officer. So 5 P's. 5 P's. I'm just giving you a hint how to make your task simpler. The things which is really cumbersome for general people, it will be very simple for you. Very, very simple for you. If you can appreciate the idea and you can innovate further. Some points you can remember, there is nothing great. If I am a student of law, I will do little bit exercise also. 11 and 14 is basically law and order, legal representative. L for legal representative and 14 is for order. Now order is order of a court. Court will give many orders in between. Now when the suit is decided, there will be order of cause, there will be order for amendment of pleading, there will be order for joinder of party, there will be many orders. There will be order for producing some document, there will be order for discovery, inspection, there will be order for summoning. So there may be many orders. There may be many orders of the court. So order is order. Order means formal expression of any decision of civil court which is not decree. Decree is final formal expression of adjudication, whereas order is any order where court will pass its own opinion on a particular point. Court will order you to do certain act, court will order you to produce certain witness, will order you to produce certain documents. So orders are of various kinds. Order is basically in a common sense expression where there is any kind of mandate by the court or any kind of direction by the court to do certain acts. That is what is order basically, in common sense. Whereas judgment is grounds for decision. Judgment is different. Now you can see judgment also. Judgment is different. Judgment means a statement given by judge on the grounds of a decree or order. So what is the ground of a decree or order? That is judgment. So we generally say it judgment. So we read judgments. We do not say court orders. We say court's judgment. Orders are various kinds of. There can be daily order in CRPC. There will be many order or daily orders passed in CRPC. That is Jiminy order. Jiminy, Jimini, Jiminy. So there may be many Jiminy orders. So day-to-day proceedings, no? Day-to-day proceedings order. So profit, property, pleader, prescribed, public officer. When there will be profit, then only you will buy the property, and then obviously there will be property dispute, so you will go to pleader and he will prescribe you how to approach the public officer and how to get this settled. So profit, property, pleader, prescribe, and then public officer. So you can devise your own method. If there will be profit, then we'll buy property, and if there will be property, there will be property dispute where I'll go to a pleader now, and pleader will prescribe me how to approach public officer and how to get remedy. So profit, property, pleader, prescribed, and public officer. This is how you can memorize things. भाई बताओ, आप ही प्रॉफिट होगा तभी तो प्रॉपर्टी खरीदोगे, and property कर दोगे, then there will be requirement of pleader to suggest you what to do, what not to do of this property. And if there is any property dispute, obviously the pleader will prescribe you the method to approach the public officer, the concerned officer. So this is how it is written: profit, property, pleader, prescribed, public officer. Is this all right? Then it says 18 rules, share and signed. So just for your memorization, my dear friend, nothing great. 18 is rules, 19 is share, and 20 is अब देखो यदि and if you do not like this word, then there can be now this, you can club them together and you can write SASI. Now this is SI, I have written SHI. R SASI. Or this word. 18, 19 and 20. Rules, share in corporation and signed. Signed includes stamped. So just read it carefully. Just read it carefully. Is it clear? So I hope you keep in mind this very simple general method. I am repeating it. 2-1 is court because it begins with court. 2-2 is decree. 2 plus 2 equal to 4. Fourth is alphabet, that is D, fourth alphabet. 2-3 is decree holder. When there will be decree, then only decree holder. And 2-4 is district. 2-5 is foreign. So there will be foreign court, then there will be foreign judgment. Government, pleader, High Court and Indian Territory. 8, 9, 10. I have already told you this is related to J, 10. So I said this is judgment and this is judgment and this judgment is given by judge. So judge, judgment and judgment debtor. Of 11 and 14 I told you to leave and rest 5 are P. So I said profit hoga, then you will buy the property and for better upkeep of property you will go to pleader. Pleader will prescribe you method. If there is any dispute, how to approach public officer. Is this clear? This is movable property and this is mean profit. This is again very important. See, this is how I can remember, and this is now before P, legal representative, and after, so LPO, this is LPO, LO, this is P, this is P, LPO. Just innovate methods. So profit, property, pleader, prescribe, public officer. And then last but not the least, 218, 19 and 20. Rules, shares in corporation and signed. But read them carefully what it says. Signed means stamped also. So be careful about this. So I hope you will develop such method, 3 Ds, 5F, 5 foreign, G high, judge, judgment, judgment debtor, and formula of 5 Ps, LPO, RSS. So just keep in mind 3 Ds, 5 Ps. Now before 5 Ps, 3D, 5 foreign, 1 C, then G high, no, G high, then this judgment, judgment by a judge and against judgment debtor. Is this clear? Then LPO, then 5 Ps, and then RSS. This is how you can remember the entire section 2. You can now get many more methods, but this is what is the summary of section 2 memorization. Is this clear? Is this all right, my dear friend? Now we are not reading definition right now, so just do it. Now, may I ask you a question? Are you feeling comfortable? हाँ कह सकते हैं, प्लीडर रूल शेयर करेगा देन साइन होगा, ठीक है, प्लीडर रूल शेयर करेगा देन साइन होगा, यू कैन से लाइक दैट. I am asking this question to all of you. Are you feeling comfortable? Now, Uh, so to keep it interesting and to keep it easy, you will have to give me utmost liberty to conduct class in my own way so that I can perform better. To make it effortless, we have to make whole effort and we have to be very, very sincere in learning and listening. I am asking this question to everyone. Are you feeling comfortable? Are you feeling comfortable? That's great. We are concentrating more on output, less on input. I am not into giving many informations to you. CPC erosion of information. I'll be dealing with hardly few things. But yes, of course, at our level, we'll be reading entire CPC. We will study and discuss everything what is relevant. I hope all of you must be little bit awareness of cricket. You might have seen bowlers bowling and batsmen batting. But have you seen batsmen playing all balls? No. There'll be many swings, many cuts. There'll be dusra, there'll be now many kind of balls which may be unplayable and he may not play it. But does he lose hope? Does he lose his calmness? And that is how out of one, some Tendulkar or Kohli is made out. If you want to be a successful student, take my word seriously, that you may not be able to solve all the questions at one point of time. You may not get answer of all the questions at one point of time. You will have to be patient. You will have to be calm. It's a great journey. And it will have many hiccups, hurdles here and there. The things may be getting sometimes bumpy also. It will give you some jerks, some jolts, but you have to be calm and patient. I will remember that there was a game which was played in New Zealand and the ball was almost unplayable. But some of Indian batsmen who were very cool, calm by temperament, they played very well and India won the game, which was almost difficult to win. So this is what is called the art of success. If you want that everything you will learn in one day, in one go, it is not going to happen. It doesn't happen to anyone. I have taken number of years to learn these simple tricks. It comes now, you may do even better. It comes by experience and effort. It doesn't come in one day. I tell you my own story. I read whole day civil suit of section 9. But I am not going to teach you section 9. Because I thought that if I take you to civil court by civil suit at the outset, then perhaps before suit the plaint has to be drafted and crafted carefully. And that point should be brought before. That is what is my thinking. I also learned by experience, little bit awareness. I cannot give you all awareness of plaint right now, but I will give you some awareness of plaint as well. I will go a little slow in the beginning. At the outset, it has to be slow. And no dictation is here right now. dictation will come little later, don't worry. Now when we reach to the topics, etc., then the dictation will come, question, answer will come. I will teach you, you will solve question, I will solve question, we will do some cases also. Like now you cannot read section 9 without understanding this Dhulabai case, which is a constitution bench judge. Many people will now ask this question, that how many cases we are required to study. I will say there is no quantification as such, but there is a clear understanding, and this understanding is very simple. Let's see, if I am reading a topic, then I should know what is the crux of that topic, what is the core of that topic. And wherever this crux or core has been discussed, obviously by a larger bench like constitution bench, then that becomes very important. So if I do not remember any case in section 9, but I remember Dhulabhai versus State of MP, my job is done. My job is done. So if I am asked a question either in mains or in preliminary, I will answer on the basis of that decision itself. Anybody who has read this Dhulabhai versus State of MP knows what is section 9 exactly all about. Because it is so exhaustive case, it's a constitution bench decision where you have quoted now many cases. So you should not now grope in dark, rather you should now come in light and you should see what is the crux of the matter. Tamso ma jyotirgamaya. So now we are in complete darkness and we are required to move to light. So that will take little bit time. So everybody, even now, even a very underconfident student who has come to this class, they will be confident if they follow the rules, if they follow the procedure. Procedure is handmaid to justice. So procedure will take you to the goal. So be careful, be calm, be considerate, be kind, be disciplined, be dedicated. हिमांशु जी जो आप लिख रहे हैं, ये तो मैं 3 दिनों से यही बोल रहा हूँ, अल्फाबेटिकल ऑर्डर में लिखा है, ये सबको पता है, ये तो पूरा सीपीसी यही है ना, शुरू से नहीं सुनते हैं आप लोग, इसीलिए आपको लगता है ऐसा कमेंट लिखना पड़ेगा, लिखना पड़ रहा है। तो ये तो मैं आपको पहले दिन से बता रहा हूँ, सीआरपीसी में भी हमने अल्फाबेटिकल ऑर्डर में चीजें लिखी है। बेलेबल पहले आएगा, देन कॉग्निजेबल आएगा, हाँ सबको पता है। बेलेबल पहले आएगा, देन कंप्लेंट आएगा, क्योंकि सी बाद में आता है। बेलेबल पहले आएगा तब चार्ज आएगा, और एच पहले आता है या ओ पहले आता है, एवरीबडी नोज दिस। सो सी एच कम्स फर्स्ट, सी ओ कम सेकेंड, सो चार्ज विल कम फर्स्ट, कंप्लेंट विल कम सेकेंड। ये आरवी केलकर की किताब में नहीं लिखा है, फॉर योर काइंड इन्फॉर्मेशन, ये रंजन्स ड्राफ्ट में लिखा है सिर्फ। तो इसीलिए मिस्टर रंजन की बात को ध्यान से आप सुनेंगे और आप मेरी बातों को फॉलो भी करेंगे। यस, हिमांशु जी, पुष्पराज जी, एंड मेनी अदर, हर्षवर्धन, many other people who are there in the class, Jia Chaudhary, Nandini Sharma, Sandeep Yadav, Shalini, Chikara, Sally, Dibya, Shriya, Ritik, Vaibhav Khattar, Gajala, Rupal, Dhruv, Karan, Tanya, Mohammad Amir, Prashant Kumar, Nidhi Mani Tripathi, Ayushi, Sunil, Prakhar, Pooja, Shweta, उज्जवल, सौम्या, सोनू, रूपाली, प्रगति, प्रशांत, संध्याली, सिमरन, हिमांशु, तरुण, पूजा माथुर, ऋषभ, अजय चौधरी, अल्फिशा, किरण, कादिर, वरुण शर्मा, मुक्ता, आई फील गुड while reading your name, प्रिया, रिया, शिवांगी, स्मिता, सिद्धार्थ, प्रियंका, वरुण, कादिर, दिव्यांश, जिया, राजरत्ना, अभिषेक, दिव्यांशु, शिवांगी, संस्कार, अपूर्वा, पूजा कुमारी, अक्षत, आयुषी, प्रियंका. So all these people, मोहम्मद, शोएब, अनुपमा, हर्षवर्धन, रागिनी, प्रशांत, नीतीश, मनीषा, रूपाली, वैष्णवी, all these people. भाई कोई स्टेट स्पेसिफिक टिप्स नहीं होता है, लगे फिर डेविएट करने. सीपीसी में स्टेट क्या होता है? यही सब भ्रम है जो मार्केट से आप लेके आते हैं. इतना सारा भ्रम है ना दुनिया में. सो यू कांट हेल्प इट. लिसन टू मी केयरफुली. मुझे पता है हरियाणा और राजस्थान सब पता है. आई एम डीलिंग विद एवरीथिंग. हरियाणा में भी सेक्शन 2 सवाल आता है, राजस्थान में भी आएगा, दिल्ली में भी आएगा. कोई स्टेट स्पेसिफिक सीपीसी नहीं है. ये सब भ्रम है. बट आप भ्रम है तो भ्रम है, आपके मन में रहेगा. आपको यही तो है. दिस इज व्हाट इज कॉल्ड एक्सपीरियंस. मेरे मन में भ्रम नहीं है. मैं हरियाणा और पंजाब नहीं करता, मैं सब स्टेट के लिए पढ़ा रहा हूं. आई एम टीचिंग फॉर ऑल स्टेट्स एंड व्हाटएवर आई एम टीचिंग इट इज हेल्पफुल फॉर ऑलमोस्ट ऑल स्टेट्स ऑफ इंडिया. बीट केरला और बीट कर्नाटका और बीट काश्मीर, बीट आसाम, बीट त्रिपुरा, बीट गुजरात, बीट हरियाणा, बीट राजस्थान, बीट पंजाब, बीट महाराष्ट्र, बीट तेलंगाना, बीट आंध्रा, beat any other state for that matter, Bihar, Chhattisgarh, UP, Jharkhand, whatever. It is useful for all. ये सब जो है ना ज्यादा भ्रांतियां, स्टेट स्पेसिफिक, ये स्पेसिफिक, वो स्पेसिफिक, ये सब भ्रांतियां हैं. These are all kind of now भ्रम which is generally done. Please avoid such questions. डेट बताने की ये क्लास नहीं है. फिर तुम लोग करने लगे. Harshvardhan, I have told even yesterday, no question in the chat, please. डेट फॉर हरियाणा तो तुम कमिश्नर से पूछोगे ना, जो वहां का है? नहीं, हम थोड़ी बताएंगे डेट आपका. हम बताएंगे पढ़ना कैसे. देखो आप लोगों को ना भ्रम है यही सर. आप किसी से कुछ भी पूछ, अब चले जाओ एक जज से पूछो कैसे सीपीसी पढ़ना है, तो जज तो बताएगा सीपीसी से डिसीजन कैसे दे. तो पढ़ना नहीं बता पाएगा वो. आप गलत आदमी से गलत सवाल कभी मत पूछिएगा. लॉयर से पूछो कि सीपीसी कैसे, तो आपको सीपीसी कुछ समझा देगा वो जरूर, बट वो एग्जाम की तैयारी नहीं करा पाएगा. आप ये लिख लो, तय है. मैं आपको बता रहा हूं, लॉयर विल टेल यू हाउ टू फाइल ए केस इन कोर्ट, हाउ टू विन लिटिगेशन. ही कैन टेल यू प्रोसीजर एंड यू विल फाइंड, ओ बड़ा मजा आया, लॉयर ने अच्छा बताया, सर ने भी इतना अच्छा नहीं. बट ही कैन नॉट सॉल्व योर क्वेश्चंस और एग्जाम, एंड ही कैन नॉट टेल यू द ट्रिक्स व्हिच आई एम शेयरिंग विद यू, व्हिच इज नेसेसरी फॉर एग्जाम. सो डोंट आस्क ए रॉन्ग क्वेश्चन टू ए राइट पर्सन. है कि नहीं? अब आप हमसे पूछेंगे एज क्या है हरियाणा का, तो मैं एज थोड़ी देखता हूं हरियाणा में क्या है. उसके लिए सिलेबस है, उसके लिए वेबसाइट है, वहां जाके देखने का. बहुत सारे लोग यही करते रहते हैं. फॉर्म गलत भर दिया तो अब क्या करें. अब सर क्या बताएंगे फॉर्म सही कैसे भरा है. तो सर ने ना फॉर्म भरने की तकनीक बनाई है, ना कोई उसका फॉर्मूला. सर आपको बताएंगे सीपीसी कैसे पढ़ना है. तो ये सब क्वेश्चन चैट बॉक्स में तो बिल्कुल नहीं पूछना. इट्स ए क्राइम. It's a crime because you are diverting others also. This is not acceptable at all. You must avoid. ये सब देखिए आपने कर लिया कुछ क्लासेस में, अब नहीं करना आगे, क्योंकि मुझे ना क्लास बहुत ही अच्छे से चलाना है. एंड आई वांट यू टू बी 100% विद मी, एंड आई वांट मी टू बी 100% विद यू. सो लेट अस गो खुली कामली. आई एम नॉट इन हरी. इफ यू आर इन हरी you will not be able to achieve the goal. Please try to understand. So be calm, cool. जो लोग पहले से पढ़ चुके हैं उनको मैंने कई बार बता दिया है. प्रिलिमिनरी की तैयारी के लिए डायरेक्ट पढ़ो, प्रीवियस ईयर क्वेश्चन बताओ, कई बार बता दिया है. यूट्यूब पे लेक्चर है, आप वहां जाके देखो. हरियाणा के लिए क्या करना है, हरियाणा की तो बात कर रहा था मैं कि मेरे एक स्टूडेंट ने कहा कि आप क्वेश्चन बनाए थे क्या सर, आप ही का क्वेश्चन सारा हरियाणा के एग्जाम में आया था. अभी भी वो पोस्टेड हैं और टॉपर हैं हरियाणा की. उनका नाम आकृति वर्मा है. बहुत अच्छी स्टूडेंट भी रही है हमारी, बहुत अच्छी स्टूडेंट. शी इज इन फरीदाबाद. सो शी वाज पोस्टेड, नाउ शी हैज टेकन लीव राइट नाउ. सो आई टोल्ड यू माय डियर फ्रेंड वेरी simply that this strategy which I am sharing, this input which I am giving to you, will have an impact on you which will produce better output. So I am interested in that. And if you are able to do it, you will pass all examination for that matter. आपका interest नहीं oral exam में, but हमारा interest सारे exam में है, which includes even Haryana and Rajasthan. There is no doubt about this. There is no doubt about this. हम लोग टेस्ट भी कंडक्ट करा रहे हैं, आपको पता ही होगा, सब कुछ कर रहे हैं, आप बस पढ़ो. सवाल ज्यादा पूछने से बेहतर है. प्लीज रीड बैरक केयरफुली, सॉल्व द क्वेश्चंस केयरफुली, you will be able to do it. Now let me go further. So I was telling you that if you see the game of cricket, you may not face all balls. And have you seen now generally a batsman playing all the ball and now making run on every ball? It is not possible. So it may happen with you also. You may not understand everything in one go. There will be many bouncers. There will be many in-swinger, out-swinger. There will be many things like this. Googly, which you may not understand. Dusra, which you did not play well. You will miss hit. So it will happen. But be careful. Have discipline, cool, calm, concentrated. Now, then we'll have better idea of the subject. So till this time, we have done few things. I told you how to keep in mind the orders and the sections. And I hope if I ask you a question that this section is related to what, not exactly the section's heading, but related to what topic. So you may be able to tell me. If I ask you a question, my dear friend, can you tell me that section 129 is related to what? Is it related to interest? Is it related to cost? Is it related to caveat? What it is related to? So you may be able to tell me very clearly कि सर ये तो rules से related लग रहा है. क्योंकि 121 से 131 में कुछ आपने पढ़ा था ऐसा. If you remember carefully, कुछ पढ़ा था ऐसा हमने. You may not remember exactly, but you may remember. When I ask you a question, my dear friend, order 44 is related to what? Is it related to reference, revision, or is it related to summary suit or friendly suit? So you may be able to tell me. How many of you remember order 44 is related to what? I told you yesterday, it is related to what? देख के नहीं बताना है. Appeal by indigent. So how do you remember this? I told you that you have to build an idea. You don't have exact idea. I'm not talking about exact idea. See, I am discussing the topics at macro level right now. Micro level I will begin after the Sahara. Macro level discussion is happening here right now, so that you can have a better perspective of the subject, overview of the subject. Then we'll go to micro level discussion. I am not into micro level discussion now. Micro level discussion at this stage may be dangerous because many people may not appreciate. See, there is a stage where you should be exposed to one thing or the other. If I expose you to complicated things at the outset, then the whole journey will be devastating for you. I know as a teacher of last 30 years experience that where I have to do what, and that is why I avoided section 9 today. Otherwise I would have started with that, because if I take you to that decision of Dullah Bhai, where the court said 7 things basically, so you may be confused about that कि ये 7 things इतनी ज़्यादा बातें कोर्ट ने क्यों कही है. So I am trying to refine it little further and I will bring before you a refined matter. So you need to work on the strategy first. Now strategy is very important in any game. So talking of a strategy, let me go a little further. If I asked you, my dear friend, what is that If you remember correctly, I told you yesterday, how will we memorize this section or other order 27 to 37? Order 27 to 37, now if you remember correctly, I told you these are special suits. देखो मैं उसकी बात कर रहा हूं, आपका आउटपुट क्या, अब आपने पढ़ लिया, पता ही नहीं है व्हाट इज दैट. So I said 27 begins with government. I said that. And 27 is related to constitution, which is related to government, you can say. 28, that was Army, Navy, Air Force, I think. And then there was corporation, firm, and that T. Trustee, executor, and administrator, whatever it was. You remember that? कुछ था ना ऐसा? CFT, I told you. If you remember correctly, government, military, and in between substantial question, constitution. I'm just giving you hint, then I'll go to next topic. Because it is very important to look back always, not fall back. Fall forward, not fall back. अब एक स्ट्रेटेजी हमारा ये भी बड़ा इंपॉर्टेंट है. CFT. So government substantial question 27A military, then I said CFT, corporation, firm, trust, executive and executor and administrator. This is 29, 30, 31. And then I said minor होगा तो family बनाएगा. So minor और unsound, then वो family बनाएगा तो 33, और यदि नहीं कर पाएगा तो ओहो 32 है. एंड जब वो ना फैमिली बनाएगा, देन हो सकता है कि वो यदि काम नहीं करेगा तो इंडिजेंट हो जाएगा. काम नहीं करेगा तो इंडिजेंट हो जाएगा. एंड इंडिजेंट क्या करेगा तो प्रॉपर्टी को मॉर्टगेज करेगा. तो न्यू दे शुड लिसन टू मी केयरफुली. ऑर्डर्स, these are orders, we are talking of orders. Order 27, order 27A, 28, 29. So CFT एक फॉर्मूला बनाया हमने, बहुत सिंपल. Minor होगा, then he will become major, so he will be family, and then if he doesn't work hard, then he will be indigent, and once you are indigent, you will mortgage your property. Then there will be claim between husband and wife, then there will be interpleader. Who is the rightful owner? 35. Then there is a friendly suit. No, sixth alphabet. अब वहां का I for 5, यहाँ कह रहे हैं sixth alphabet. This is 36, order 36, friendly suit, and then summary suit. 7 for summary. So I remember it. Now this kind of formula will help you to memorize section based, order based question, and you can solve them very easily. If you are not able to do it, that is your problem, because I will be telling you time and again. अब जैसे कल भी, if you remember correctly, I said many things in between. 89 is arbitration, conciliation, mediation, judicial settlement. I said that 89. 90 is opinion of court. 90 opinion. I said this. Then I said charities, nuisance, something like that. Advocate General. Now, if you remember, because ध्यान होगा आपको, you may be remembering that. Sound is breaking. I am not breaking, I hope. No? Is it clear, my dear friends? अभी भी साउंड क्लियर नहीं है आपको? Sound is breaking. I am not breaking, I hope. Okay, no issue now. Ah, so sometimes problem comes, no issue. I might have committed the mistake. It's all technical system. So now I said then that interlocutory, now interim orders are there. I said 24 onwards. 24, 25, 26, and that 38, 39 and 40. That is how we remember. Now this is PSC, I hope. No? C for commission, PSC. This is security for cost. You just check it, and this is payment into court. PSC, Public Service Commission, and this side AIR, receiver, injunction and attachment and arrest. So this is what is to be done again and again. You should not forget all these things. And 1 to 20 you remember clearly, I hope so. That is clear? So यहाँ तक तो हम लोग clear हैं. Now in this journey, as I said earlier that the civil suit, मुझे पूरा विश्वास है, I have all confidence that you have followed me very well and you will memorize all these things and you will try to memorize even better. You write down important concept in one word. Like now, if you have to remember where is caveat, so 148A has caveat. So you pick up the important things by looking into the questions. If you want me to do this, I can do it, but that will be not your learning. आप कट कॉपी पेस्ट स्टूडेंट मत बनो. If you want to be a brilliant chap, if you want to be a brilliant judge, if you want to be a brilliant lawyer, it doesn't matter from where you have come. It doesn't matter how much law you know right now. It doesn't matter which book you have read. It doesn't matter from which university you have come. It doesn't matter what you did till yesterday. It doesn't matter whether you knew this fact or not, that you are very intelligent. You are very, very intelligent. Just have self-belief. You can do wonders. Just follow the idea. Now when I point out before you again and again, education is not the learning of facts. It's rather the training of mind to think. So I will train you to think properly, which might be the missing link. And if you start thinking properly, you will find that you, an ordinary student, has become an extraordinary person. Everybody will praise you. Everybody will praise you. I tell you, my dear friend, once some people from Bar Council came here to my office. They wanted a lecture for judicial preparation in their court premises. So when they came here, they were not aware that I am and this is talk of 2007, I hope. 2007, so 14 years back. 14 years back. So they were not aware that I am not so old as they might have believed. I was hardly at that time 36 years old. So they could not believe that 36 years old person will address all the lawyers who may be of 50 years even. Because they will come to listen, they may not be interested in preparation. It was a packed house there. But let me tell you, when they came here, they said, what will you teach us? Because we know the law. I said, I am not going to teach you the law. Because you may be knowing better than me, because your experience is more than me. I'm not going to teach you law as such. I will teach you how to study, I'll teach you how to memorize, I'll teach you how to pass examination, which you are not aware better than me. Oh, they said, yes, it is so. Bar council secretary was there, something like that. Some people were there, 4 or 5 people came to me and they said that, can I see demo for 5 minutes or 10 minutes in your class? I was sitting with them in their office, in my office. Now the office is at Main Road, but it was here in near my classroom from where I am speaking right now. So, we came together to the class and I gave them 30 minutes lecture. They were all surprised at how can one memorize so many sections in one go. You may not be aware of my memory limits right now. I will memorize IPC, I will memorize even constitution, I will memorize even contract, I will memorize even little bit more subjects, because I have been reading those subjects a little bit. So don't worry about that. And as far as building of concept is concerned, I have written in one of my barrack, I am happy to say that we have sent IPC for publication, for publishing. It will take another 5 days for getting it published, because it's not an easy job. So I wrote a preface there for students, that law may be lax or law may be just. Or I wrote like this, that law may be just or lax. Just means that it is rules of natural justice, lax means any enacted legislation as such. So law may be just or lax, but it is not complex. Rather, it is common sense and logic. And I firmly believe in it even today. Be it CPC, be it CRPC, when you do not find any answer to the question, apply your common sense, you will have best answer, I tell you. So this is what is the training of mind to think in proper direction. पोथी पढ़ी पढ़ी जगमुआ पंडित भया न कोय, ढाई आखर रंजन ड्राफ्ट के जो पढ़े वो पंडित होए। तो आपको ये बात समझनी पड़ेगी। You will have to appreciate and understand that bare act को ध्यान से पढ़ना है, previous year question खूब बनाना है, and wherever you find it difficult, you please consult the teachers, they will help you. Please take help of your friends also. You will be able to do it. So let us come back. And don't be in hurry. ये सवाल नहीं बना, वो नहीं बना। बहुत लोगों को कंप्लेन के बड़े एटीट्यूड है, बड़े प्रॉब्लम है। एक क्लास नहीं हुआ, 2 क्लास नहीं हुई, सर ने आंसर राइटिंग नहीं डिस्कस किया, सर ने अभी डिक्टेशन नहीं दिया, सर ने अभी कहां से कर देंगे? अभी तो आपको हम बच्चों की तरह सिखा रहे हैं। आप इतने बड़े विद्वान हो तो लेके आ जाओ, क्वेश्चन आंसर ही शुरू कर देते हैं। हम पढ़ने की जरूरत ही नहीं है हमें। क्लास तो ऐसी भी हो सकती है। देखो, देयर कैन बी डिफरेंट क्लास फॉर डिफरेंट क्लास ऑफ पीपल। If you have read CPC very well and you know everything in CPC, then there is no point in studying CPC. And if you memorize entire CPC, then there is no point in dealing with these memory techniques. It's useless. 3 Ds and 5 Ps and 2 apps and RSS. What is the use? It's useless then. So let us discuss the question then. But is it so with everyone here in the class? It is generally not so with us. So let us concentrate on first understanding the concept, then let us apply the concept. Let us solve the questions. ऐसे हर के पढ़ाने का तरीका अलग अलग होता है. When Socrates used to teach his disciples, then if anybody will ask him question, he will say, you think over till you answer the question. I am not going to give you answer. And that is what he says. He is very beautiful. Now he gives very beautiful expert comment and he says that this will be your learning. It will be my learning if I answer your question. So Albert Einstein is not saying anything different. So all great people say same thing. He says that you train the mind to think. You don't be looking for an answer from the teacher always. Sir, ये मन में आया, group में लिख दो, chat में लिख दो, आप जवाब दे दो मुझे. This is not the way. This is not how you can make yourself intelligent. This is what is going to make you now even a judge, but not an intelligent judge. So be careful, be cool, be calm. You will understand everything, but with little bit patience. Now, let us come to the point and let us discuss further. We are going to discuss the procedure of civil law. I have said even yesterday that this procedure of civil law begins with the civil suit. And civil suit is filed in section 26, and section 26 says every suit will be filed by filing a plaint. Now, the moment we go to file a civil suit by filing a plaint, the question will arise that how will we draft a plaint? And what kind of rules, regulation, restriction, principle, particulars, points we should take care of. Drafting of plaint is an important art. Why it is an art? Because the whole matter will depend upon your plaint, how you have drafted it. If your beginning is not good, your end can never be good. So well begun is half done. So you have to write a beautiful plaint. And to write a beautiful plaint, you should know exactly what is to be done in the plaint. What is the integral part of the plaint and what is not integral part of the plaint? What are the rules and regulations of the plaint? Should it be written in a story form or should it be written in para form? What should be done? What is your task? How this journey will begin? So basic rules relating writing to plaint, writing of a plaint is written in order 6 and 7. I'm talking of drafting a plaint, writing a plaint. I'm not talking of other rules. Because if you read order 6 and order 7, you will find even amendment of pleading, you will find even admission of plaint, rejection of plaint, return of plaint. So we are not discussing that point right now. I'm talking of drafting of plaint only right now. How will you initiate the proceeding? Now, I'll be talking of various rules here. I'll be talking of various rules. I'll be talking of various rules here, and I'll be suggesting you what to do in drafting of plaint. Is there any difference between drafting of a plaint and drafting of a petition? Is it necessary to write law and evidence in plaint? Is it necessary for plaintiff to know all the law and evidence beforehand? What is to be done in writing of the plaint? What kind of rules, regulations we have to follow? We have to keep in mind while drafting a plaint. Just wait for 5 minutes, I am going to discuss this point with you today itself. I will be starting with this plaint just after 5 minutes. Is this clear? Or maybe 10 minutes. I say 5 minutes, but always I take 10 minutes. So be in rest for 10 minutes and then I'll begin. All right? I said let us begin our journey with the idea of plaint. अब प्लेंट लिखने में, पढ़ने में किन किन बातों का ध्यान रखना पड़ेगा, we'll understand little bit. I'm not going into great detail, it's beginning, so I'll begin very slowly and steadily, and I want you to be very comfortable in this class, so I'm not in great hurry. I hope you must have seen how train starts and how plane flies. So it goes slowly in the beginning, then it picks up. No? And then again, when it has to stop somewhere, it will slow down. So we'll do that. So we are picking up. But CPC, yes, so will be little easier, calmer, cooler. So I said that how will we draft this plaint, what will we do and how will we do? So I tell you, drafting a plaint without going into much detail is much related with the précis writing. See, a client comes to you and he will tell you many stories. He will talk about violation of his rights, he will talk about many things. Then you are required to decide the question that which rights are violated. कौन सा right यहाँ violate हो गया and what kind of remedy should be sought. So you should have idea of basically law, but that is one part. But besides that, you must understand that when you draft a plaint, it has to be very precise, very concise, very brief, to the point, so that judge is not required to waste much of his time, and he should be told categorically that what is the exact issue and what is the exact relief which is being sought here. Is this clear? So to tell him exactly, you are required to learn this art of précis writing. You must be aware of that fact that in school age you must be must have seen that you have been given 5-6 pages and then you are required to produce the same idea in few paragraphs. And you are required to write all idea in that few paragraphs, and that is what is called précis writing. This is same which is required to be in plaint drafting. This is same. I'll talk about the rules also a little bit, but it has to be précis writing. And preciseness and brevity is soul of wit. This is what is wisdom. How can you express your things briefly? And this is what we are required to learn in answer writing also. I'll tell you, many people have this concern, so I'll tell you. How to write your ideas in brief. This is what is art of answer writing. So précis writing is the first thing which you are required to inculcate. Then second, you should write it in active voice, not in passive. आप स्टोरी नहीं सुना रहे, अब देखो अंग्रेजी का भी यूज है. And suppose I said précis writing, I said active voices has to be used. So you will have to have understand of little bit English as well. So English grammar and usage is very important. Suppose I communicate my idea to you and I speak incorrect sentences and I use grammar incorrectly in writing of my books and writing of my barracks and writing in dictation of my answers. How will you feel about it? Will I be able to make good impression on your mind? The answer is no. So it is very much required that you should be, I will not say that you should be perfect always everywhere, but you should have good idea of your English grammar and usage in writing of draft. And this will apply to your answer writing as well. You ask me question always about answer writing, I am answering those things and I'll be answering it time and again. So you should have good command over your English language, your grammar, your usage, your sentence formation, clear communication of idea in brief. So précis writing one, active voice sentences is another. Third, I said grammar and usage should be taken care of because you will not be able to make impact on the mind of judges from where you are seeking the relief. You cannot communicate your idea. Now, what kind of impression you will have about your intelligence? If you do not write proper English, proper grammar, proper usage, so that has to be taken care of. It should be simple, it should be straight. It should be simple and straight. Now see, generally, your client will give you the facts. He is not going to tell you the law. He is not going to tell you the law. Your client will come and he will tell you that what happened to him. But he will not be able to tell you the law on the point. So as a lawyer or as a judge even, or as a counsel or as a student even, you are required to know the law on the point. Though plaintiff says that you are not required to write law, you are required to write facts. But if you know the law, then you will be able to use your facts according to the law, according to the requirements of the law. Now, what I am trying to communicate, I can give you few examples. Just let me have the Bare Act also. Negotiable Instrument Bare Act and SRA Bare Act. SRA and Negotiable Instrument, Bare Acts. So, I can give you example that if you do not know the law exactly, you will have problem in writing a plaint. You will have problem in writing a plaint. Because what is plaint? And if I talk of plaint, let me ask you, is there any definition of plaint anywhere? No. CPC does not define plaint. CPC does not define plaint anywhere. We are going to draft a plaint, write a plaint, so we should know what is plaint exactly. I am telling you the rules of writing plaint basically. The basic rules without going into nitty-gritties of legal rules. So, I am asking you a question. What is this plaint all about? Is it defined in CPC? No. So, what will we do? How will we write a plaint when we do not know what is plaint exactly? So, I tell you that plaint has been defined in certain cases here and there, and it is written in those cases. You can also note down. Plaint is a private memorial. Private memorial tendered to a court which the person sets forth, where the person, that will be better, where the person sets forth his cause of action. Now, on what basis he seeks action of the court? What is the cause behind that particular action which he seeks from the court? Tendered to a court where the person sets forth his cause of action. Plaint is a private memorial tendered to a court where the person sets forth his cause of action. And it has very important object. And the object is to enable the court to decide whether there is cause of action or not. And furthermore, if written statement, that is a statement of the opposite party comes, that is called written statement. Plaint is basically Pleading of plaintiff. आप जानते होंगे कि the aggrieved party who goes to the court, he files a plaint. If I am aggrieved by certain violation of my right by the other party, suppose I am A and other party is B, and B violates my right, so I being A aggrieved, I will go to the court and I will take a plea before the court that see such and such rights are violated. So to show this fact that such and such rights are violated, I should know the substantive law of that particular thing of which I am alleging. If I am alleging that contract is violated, how contract is violated, that has to be now shown basically, that contract was agreed into or entered into on such and such date with such and such person, and it was promised that such and such thing will be done, and it has not been done. So you just order him to now perform his part. So specific performance of contract can be asked for. But whenever you ask for this specific performance, then before 2018 amendment of this SRA, there was a requirement in section 16C that whenever you write a plaint, then you are required to aver the fact that plaintiff was always ready and willing. This is still a requirement, that plaintiff was willing and ready to perform his part, and he has performed his part. So that is still there. But it was specifically mentioned in section 16C that you have to write this. And in many a decision, the courts have said that if you do not ever or write in the plaint that you are ready and willing to perform your part, you may not be entitled to relief. Your plaint will be rejected. So if you do not know this law of section 16C of Specific Relief Act 1963, how will you prepare a plaint well? So I said plaint is a private memorial tendered to a court where the person sets forth his cause of action. Now just to explain to the court cause of action, you are required to tell the court how this cause of action arises. And to tell the court how this cause of action arises, you are required to know the substantive law where the cause of action arose. If you are talking of contract, you should have little bit idea of contract law. So it is not necessary that you should be well versed with contract law and you should have read all books on contract law. I am not saying that. I am saying that as a lawyer, as a judge, or as a student of law, you should have awareness of that particular statute regarding which you are claiming a right in court of law. So awareness of law is required, though law is not required to be written in the plaint. But you can draft a plaint only if you know the law. If you are alleging that there is a building which has been constructed by violating the law and you do not refer to building regulations and zonal regulations, how can you draft the plaint? So you must take this very carefully, that before drafting a plaint, it is your first and foremost duty to make yourself aware of the law. Because client will come and client will tell you only this fact, that these are the things which has happened to me and I want relief from the court. But under which law relief will be granted and by which law cause of action arises, that you know only. So awareness of law as far as substantive law is concerned, awareness of law as far as procedural law is concerned, it is necessary for you as a lawyer or as a person of legal fraternity, you must know this fact. You must know this fact. Is this clear? Is this all right? Is this all right? Then I'll read the rule of pleadings also. So know the law basically. So I said if you are alleging that there is some construction of building which is violating the law, then you are required to tell the court how this building is violating the building regulation or zonal regulation for that matter. If you are not able to tell the court that how these regulations are violated, court may not grant you relief. Because court is not going to. So you should know, though you may not mention it there in the plaint, but you should know, and you should. Now if you know the law, it's always better for you that you can now reorient your plaint in such a way that you can now show to the court cause of action. That see, as per this substantive law, this regulation, these rules, now these things have not been done, and that is how cause of action arises. So if you do not know So legal issues are required to be known. So plaint is a private memorial tendered to a court where the person sets forth his cause of action and seeks action of the court. This is what is plaint. This is what is plaint. Many cases this has been decided, but naming the case is not required at all. So basically, in other words, if I am allowed to say further, it is, I said number one, it is a kind of a statement of claim. So you claim here something, that see I have given him money and he has not returned the money. Of course, your claim should be supported by documents, if there is any. So don't forget to Order 7, Rule 14. No? Then it should mention the grounds on which you seek action. So this is very brief. So be careful, my dear friend, what I am saying. What explain again? What explain again? What you need? भाई ये class है, please. If you are sitting somewhere else and not attending the class, this is not going to help all. What explain again? Tell me. I have explained so many things. क्या explain करना है मुझे ये तो बता दीजिए आप. आप मुझे कृपया बताएं कि मुझे क्या एक्सप्लेन. देखो इससे क्या होगा ना कि आपका बाधित होता रहेगा क्लास, इसलिए आपको थोड़ा सिंसियर होना है. अब आप कहीं आराम कर रहे हो और फिर मुझसे कहोगे कि एक्सप्लेन अगेन, तो बड़ा मुश्किल हो जाएगा. प्लेंट फॉर्मेट एड्रेस, ये क्या कर रहे हो तुम भाई? ये सब आदतें बंद करो. मैं कितनी बात कहूं? प्लेंट फॉर्मेट और एड्रेस ये कहां से आ गया? अभी हम प्लेंट फॉर्मेट पे हैं ही नहीं, प्लेंट एड्रेस पे है ही नहीं. What are you doing? Why are you now going beyond? Must stop writing of this in. No. Ayushi Rajput, no such question, please, not at all. Address, Mohammad Soeb, कहाँ हैं? Are you lost somewhere? हमने प्लेंट फॉर्मेट के भी चर्चा ही नहीं की. Why are you going in advance? You must stop all this habit. This is online class. Utmost restraint is required. This is how we can spoil the environment. Sir, please believe me, I am speaking with open heart and whole confidence at my hand. Don't write anything in chat. I know I have to discuss plant format. Don't go in advance. I will discuss even decree, but I will take 20 classes, then I will discuss decree. भाई आप लोग विद्वान हैं, इसके लिए आपका बहुत बहुत स्वागत है, बट हम प्लेंट फॉर्मेट के भी चर्चा नहीं कर रहे हैं. लेट मी डू इन माई वे. विल यू टीच मी हाउ टू डू इट? भाई आदित्य प्रताप सुनाई नहीं पड़ रहा है क्या? क्या है ये? ड्रामा कर रहे हो क्या? पढ़ाई कर रहे हो? कंप्लेंट वर्सेस प्लेंट मैंने कहा है ना चैट में नहीं लिखने के लिए. आई हैव टोल्ड यू नॉट टू राइट इन चैट. You people must be disciplined, otherwise it's very difficult. Now you can disturb anyone in the class. I don't like these things at all. I have told you. Don't go beyond plant format, address, complaint versus plant. कुछ से कुछ लिखना है क्लास में. आदित्य प्रताप, No. Why did you write this? Can I know the explanation? Even after repeated request not to write in chat. I know complaint versus plaint. What is this? This is very simple. किसको नहीं पता ये? कुछ भी मन में आया लिख दो. CRPC वर्सेस CPC, मैन वर्सेस वाइल्ड. अरे क्या कर रहे हो क्लास में? आई एम डिस्कसिंग कंप्लेंट. आर वी रिक्वायर्ड टू डिस्कस कंप्लेंट हियर? हाउ दिस इज गोइंग टू हेल्प योर अंडरस्टैंडिंग ऑफ प्लेंट विच आई एम डिस्कसिंग? अभी तो मुझे प्लेंट में भी 2 क्लास मुझे प्लेंट में लगेगा. अभी तुम कहां से पहुंच गए फॉर्मेट पे? एक ने फॉर्मेट पूछ दिया, दूसरे ने एड्रेस पूछ दिया, तीसरे ने कंप्लेंट पूछ दी. व्हाट इज दिस ड्रामा ऑल अबाउट? आई थिंक दिस इज नॉनसेंसिकल. This is not at all entertainable in this class. I am not going to entertain all these things. This is now really not going to help you, any one of you. If you want to understand law, you believe me, you follow me. If you do not want to understand law, then you must not follow me. This chat is not to write anything. No. It distracts me also. मैं क्या बातें करने जा रहा हूं, तुम कहां आ गया? ये फालतू के सवाल पूछ लेने से लॉ थोड़ी सीख जाओगे. नहीं नहीं, ऐसे लॉ नहीं सीखा जाता. ऐसे लॉ नहीं सीखा जाता. You are confused. You don't do it, for God's sake. This is the last time I am telling everyone who has this habit, please. I know 99% people are very good in this class, but 1% are somehow misguided. Though they may be innocent, I can believe that. But this is not the way that you write in chat. It is not freedom of expression here, sir. No. Yes, I am going to discuss everything. You don't know what I am going to discuss. Unnecessary writing in chat box, I know it is fatal to all. Unnecessary, then everybody will write. कुछ से कुछ लिख दो. CRPC वर्सेस CPC सर एक्सप्लेन करो. FIR वर्सेस CIR, कुछ भी लिख दो. ये क्या है? I don't know why did you write this. I don't know about all three. Why did you write this? Laughable, Subham Chauhan. Do not look at. Do not look. How can I? How, मैं अपने आप को देखूंगा? I cannot. Now this is very difficult to teach in room. We are not accustomed to all these things. We always wanted offline class. We wanted the student, but this is online has become reality now. We are going to continue with this. So don't give this kind of suggestions. शुभम चौहान, डू नॉट लुक एट कमेंट सेक्शन. ये आपके लिए प्रैक्टिकल होगा. आप बिना देखे हुए मोबाइल को पढ़ ले रहे होगे. इट मे बी पॉसिबल फॉर यू बट नॉट फॉर मी. सो दिस इज अनवर्केबल आइडिया. सो डोंट सजेस्ट एनीथिंग विच इज इम्प्रैक्टिकल. Don't look at. So you don't look at. Now, how can you give such wild idea in class, no? Subham, I don't believe this. This is really now. Wild suggestion. नहीं नहीं, क्लास में आप कोई नहीं लिखेंगे. कोई आइडिया नहीं चाहिए, कोई सजेशन नहीं चाहिए. जब तक मैं आपसे कुछ नहीं पूछूंगा, आप कुछ भी नहीं. इतना डिसिप्लिन आपको होना चाहिए. अदरवाइज यू विल बी ऑर्डिनरी. You will never be able to extraordinary. Believe me, my dear friend, extraordinary people are very disciplined people, very dedicated people. And you need to concentrate. Subhamji is suggesting that if you are singing a song and somebody is serving you, then you don't look at him, you sing a song in different world. This is highly impractical idea. I don't know how did you write that comment in chat box. You should know that this is class. Chat box is not chat box, it's a class. So you must know what you are writing. You do not write unless and until you have some idea. Anybody wants to write anything more? You write first, then I will speak. You write first, then I will speak. कुछ से कुछ करते रहना है क्लास में बैठ के, यही सब ना. दिस इज व्हाट इज साइन ऑफ रॉन्ग थिंग. दिस इज साइन ऑफ indiscipline. I don't like, I want you to be disciplined. My dear friend, देखो डिसिप्लिन नहीं होगा तो तुम सफल ही नहीं हो पाओगे कभी. जीवन में सफल होना है तो सबसे पहले डिसिप्लिन बनो, डिसिप्लिन्ड बनो. बिना डिसिप्लिन के तो तुम कुछ कर ही नहीं पाओगे लाइफ में, कुछ नहीं कर सकते, कुछ नहीं कर सकते. और लोग बहुत बहुत सजेशन देंगे, जैसे इन्होंने कह दिया गो हेड सर, वेरी गुड, गो हेड सर, सर इज रोबोट, सर इज रोबोट, गो हेड सर. You people are wonderful, wonderful experience I am having, wonderful experience, wonderful experience. अभी तो आगे आप लोग कितना डिस्टर्ब करेंगे पता ही नहीं है. जैसे मेरा एक्सपीरियंस है कि इस ऑनलाइन क्लास में देयर आर सम पीपल, नाउ एटलीस्ट 5% people in class are always in the mode of disturbance and creating negativity. So we'll take necessary action as and when required also, so don't worry about that. We have to maintain discipline in this class. I am very clear and categorical in my mind. I remember that Gandhiji stopped one satyagraha only due to this fact that there was some people who became indisciplined. You know this chora chori, etc. So he stopped his movement because of violence. So discipline is key to any revolution. Discipline is key to any success. So if anybody crosses the limit, then but for God's sake, will be compelled to do something. Will be compelled to do something. There are certain people who think that they are very smart and they can teach the other people, but this is totally wrong, because the moment you know that I know and I am smart, then you are the most foolish person on this earth. So believe that you are good, believe that you are intelligent, but don't believe that you are more intelligent than others. So that is how you will have modesty, and that is how your learning capacity will be better. Everybody can learn something from other. So you can learn from others. Have the learning attitude. Don't write too much. Speech is silver and silence is golden. I will have to concentrate to write better and to make you. इसको ना चैट ऑप्शन को बंद कर दो कुछ देर के लिए. ये चैट ऑप्शन को डिसेबल कर दो. विल डू इट लेटर ऑन. But see, this is not good. Again and again I am required to tell you one thing, and just for now 1-2 people who are in great hurry, किसी को फॉर्मेट चाहिए, किसी को एड्रेस चाहिए, तो अपने घर का एड्रेस लिख लेते. और फॉर्मेट तो दिया हुआ है सीपीसी में, मुझसे जानने की क्या जरूरत है? जो चीजें यहां दी हुई है मुझसे जान के क्या, आप ही बताइए. मैंने बुरा नहीं मानिएगा मेरी बात का, बट आप बताइए मुझे, आप जो ये लिख रहे हैं ये नॉनसेंसिकल नहीं है, तो मैं इसको क्या समझूं आपकी तरफ से? आप ही बता दो. आप पढ़े लिखे लोग हो, आपको कैसे देखो, इंडिविजुअल बिहेवियर अलग होता है, और जब समाज में बैठते हैं ना हमारा बिहेवियर अलग होना चाहिए। आपको ये नहीं पता है कि इसमें इतने सारे फॉर्मेट दिए, जाओ घर पे देखते रहो बैठ के, यार क्या है ये, इतने सारे फॉर्मेट दिए हैं सीपीसी में, इतने सारे अपेंडिक्स से कल भी आपको बताया मैंने, आप देखो ना फॉर्मेट बैठ के, मेरे से क्या पूछ रहे हो, ये सब बच्चों वाली हरकत कर रहे हो। कोई कह रहा है एड्रेस तो जो होगा एड्रेस लिख देना, अपने घर का एड्रेस लिख लो, मेरे यहाँ का एड्रेस लिख देना, एम्बिशन लॉ इंस्टीट्यूट 110 विराट भवन डॉक्टर मुखर्जी नगर दिल्ली 9। क्या करोगे इसका सर? आप देखो फालतू की चीजें जितनी पूछोगे मैं उतना डिस्ट्रैक्ट होऊंगा, मैं उतना परेशान होऊंगा। आपको ना ध्यान रखना है, देखो आपके लिए क्लास बहुत महत्वपूर्ण है, लेट मी डू इट वेरी स्मूथली। मैं चाहता हूं बड़ा कंफर्टेबल हो क्लास, बड़ा कूल हो क्लास, सबको मजा आए। ये मजा तभी आएगा व्हेन यू लीव मी इन पीस, यू गिव मी utmost फ्रीडम टू डील विद द सब्जेक्ट। If you are now better equipped to deal with the subject, come here. I will now have you in my team, and I want you to be doing something great for all of us. Nothing wrong in it. आप एक केस का ब्रीफ बनाओ, केस का प्रेजेंट। मैं एक आइडिया देना चाहता हूं अपने सभी स्टूडेंट्स को, प्लीज। You read a beautiful case, prepare a brief of the case, and I will give you opportunity to speak in the class for 15-20 minutes on that case. You will speak, we will listen. And that is how you can now present your idea better, and you can gather confidence also. You can do great as well. Is this clear? So that kind of innovative thing should be done. मैं आपको पहले पढ़ाऊंगा एक टॉपिक, फिर उसके सवाल लूंगा। अभी प्लान ड्राफ्टिंग पे मैं सीखना भी है कैसे करना है, फॉर्मेट अपने आप आ जाएगा। Why are you in hurry? Why are you impatient? कोई फायदा तो है नहीं उसका। से क्या होता है, देखो मेंटल पीस बड़ा जरूरी है क्लास में ना, आपको समझना। ये टीचिंग जो है ना, टीचिंग कोई मैकेनिकल प्रोसेस नहीं है। ये क्लास ना इस चीज के लिए नहीं है, ये क्लास आपके सीखने के लिए है। हमारा काम आपको सिखाना है, तो मुझे अपॉर्चुनिटी दो ना। जब मैं सिखाने में कहीं मेरे से भूल हो जाए, कमी हो जाए, तो इट इज योर क्लास, यू आस्क मी, आई विल एड्रेस ऑल योर क्वेश्चंस। बट अभी समय नहीं आया उसका, समय आएगा 1-2-4 क्लास के बाद, तब लगेगा, तब आएगा। हाँ, नाउ दिस इज टाइम टू रेज क्वेश्चंस। बहुत सारी चीजें आपको हो सकता है नहीं समझ में आए, आप मुझसे पूछोगे, इट्स माई ड्यूटी टू टेल यू। बट अभी नहीं, अभी इतना परेशान मत हो, इम्पेशेंट मत हो। मैं बार बार आपको संदेश दे रहा हूं, लेकिन आप वही कर रहे हो जो आप पीछे भी करते रहे हो, और इसीलिए पीछे कुछ लोगों को परेशानी हुई, क्योंकि बाकी लोगों को कंट्रोल नहीं है, वो कुछ से कुछ लिखते ही रहते हैं लगातार, and it creates a problem for everyone in the class. I also used to see your class, and I was very disappointed to see that everyone, anyone now can write anything in the class at any time. This was really ridiculous, and it creates all kind of problem. Teacher will not, I will not be able to concentrate in this way. Now, yes, I think साइमा इज परफेक्टली ऑल राइट। यहां पता नहीं बच्चों को क्या है, आप तुरंत सजेशन भी दे रहे हो, एक साहब वो सजेशन दे दिए, दूसरे दे दिए, मूव फॉरवर्ड, जैसे लग रहा है कोई मैकेनिकल चीज है। आई कैन नॉट कंसेंट्रेट एंड आई कैन नॉट डिलीवर द बेस्ट इफ यू डू लाइक दिस। यू बी डिसिप्लिन्ड। तुम अभी बच्चे हो, मान लो इस बात को मेरी। आई हैव बीन प्लेइंग दिस गेम फॉर लास्ट मेनी ईयर्स. So believe me, let me have peace, let me have now little bit comfort in this class. Now let us concentrate further. I will not be able to produce the same effect because you have disturbed me a lot, and I don't like this at all. Please, please believe me. I am sincerely telling you, my dear friend, let me come out with the best. And for best I need perfect concentration. आपने देखा होगा जब क्रिकेटर खेलता है तो उसके सामने एक स्क्रीन लगा रहता है, थोड़ा सा मूवमेंट होता है So he is disturbed and he says that you please move this way or that way. You might have seen that in game. So ये लोग जो suggestion दे रहे हैं मुझे don't look at this and move forward, sir, please ignore it. So you don't have that feeling that what kind of pressure I am having here right now. You don't know that. आपने कभी पढ़ाया नहीं, आपको पता ही नहीं है क्या होता है यहाँ. आप तो ऐसे ही इसको खेल समझ रहे हो. खेल, ये खेल नहीं है भैया, ये खेल नहीं है. पढ़ाना खेल नहीं है. पढ़ाने के लिए यू नीड टू कंसंट्रेट, यू नीड टू वर्क हार्ड. ये क्या है, डेली डेली क्या होता है ये? हाँ? क्यों रखा है इसको यहां? यहां क्यों रखे हो इसको? पहले तो हम क्या करेंगे इसका? एक तो बच्चे डिस्टर्ब करते हैं, एक तुम लोग डिस्टर्ब करते हो. मैं परेशान हूं यार. Pleading is the course which will decide, or pleading is the path. You can say path again and again, course not. Pleading is the path which will decide the course of action. Now, this pleading is plent for plaintiff. एक्चुअली कुछ लोग लॉ को पढ़ने का मतलब समझ दिए क्वेश्चन रेज करना. अरे लॉ में क्वेश्चन रेज करने के लिए तुम्हें बहुत पहले पढ़ना पड़ेगा. तुम ना अभी लॉ को सही ढंग से, बहुत लोग तो पढ़ना ही. दिस इज व्हाट इज द आयरनी विद द सब्जेक्ट. आप देखो ऐसा है ना कि आदमी को ना पढ़ाने का एक मूड होता है ना, हंसी खुशी से पढ़ाना. आई मस्ट बी वेरी हैप्पी वाइल टीचिंग एंड यू मस्ट बी वेरी हैप्पी वाइल स्टडिंग. If I spoil your mood or you spoil my mood, this class cannot run smoothly. So that is why I asked you first day, are you happy? Even today I asked you, are you feeling comfortable? Why I asked you this? It is all, see, now I tell you, information with emotion. Retention will be better. Information devoid of emotion, retention will be very poor. So your emotion is very important. You do not know this fact. If you know this fact that if I am in happy mood, I will teach better. If you are in happy mood, you will learn better. So you make your environment very happy. Make my environment also happy, my dear friend. You people are wonderful. Please be happy. Please believe. Even after so much of things I said yesterday also, भाई तुम सवाल पूछना लास्ट में, तुम्हारी जो भ्रांतियां हैं, भ्रम, कुछ भ्रांतियां तो है नहीं, अननेसेसरी की चीज आपने लिखी. जो भी तीन लोगों ने लिखा अननेसेसरी लिखा, वो भ्रांतियां नहीं, वो आगे बढ़ बढ़ के भागना है. This is not fair, I tell you. I don't want to now disappoint you, but this you have disappointed me. This is not fair. मजा नहीं आएगा ऐसे. लिखो, मैं लिख रहा हूं, बेसिक रूल्स बता रहा हूं आपको प्लेंट के. इसी पे हम लोग आगे बढ़ेंगे. प्लीडिंग टू स्टेट मटेरियल फैक्ट्स एंड नॉट एविडेंस. तो आपको प्लेंट में कभी एविडेंस नहीं लिखना होता, प्लेंट में कभी लॉ नहीं लिखना होता. Plaint has to be based on the facts, material facts. And on this, now we say there are two kind of facts. There are two kind of facts, facta probenda and facta probentia. Facta probenda is to be brought in the plaint. Facta probentia is evidentiary fact. Now this evidentiary fact should not be brought in the plaint. Now let me tell you, you should write only that much which is required. जैसे आपने कहा कि A and B entered into a contract on 1st January 2018, and as per the agreement, the goods were to be supplied on in January 2019. January 2019 elapsed, but they did not supply the goods. So, breach of contract occurred, cause of action is there, so you are seeking relief. Very plain and simple. Now, you should not go beyond this. You should not write, and you should not go in this fact that who and how that contract was entered into, who was behind that contract, who broke that deal. So, we are not interested in that. There was third party who was friend of mine and third party was friend of him also, and he now brought us to negotiation table and then we entered. Now, these things that the third person was involved and he brought us on negotiation table and then we entered into contract, these facts are not material facts for cause of action. Now, what facts we are required to bring, I will explain it even further again and again, but let me tell you, here we are required to explain in the plain that how cause of action arose. So, cause of action arose in simple way by entering into contract and by breach of contract. So, you saw entering into contract and you saw breach of contract. So, your fact should relate to these things. There is entry into contract, there is breach of contract. What was that contract all about? When it was entered into, what was promised and how it was breached. That's all. You don't go into the background of the contract. That is not required at all. Very basic. हम आपको प्लेंट सिखाएंगे लिखना अभी. Don't worry. थोड़ा सा समय दो अभी प्लीज. अभी पहले बेसिक रूल्स को पढ़ो. अभी अब मटेरियल फैक्ट क्या है, मैंने बहुत बेसिक एग्जांपल दे दिया. आई हैव गिवन यू वेरी बेसिक एग्जांपल ऑफ व्हाट इज मटेरियल फैक्ट and what is evidentiary fact. So, evidentiary fact is not required to be pleaded. What is to be pleaded? These are basic rules of plaint writing. Now, then you write further. Every pleading, आज आपको लिखना ये सब, should be divided into paragraphs. All necessary particulars must be stated. All necessary particulars, not unnecessary. Now see, on this point you can see this order 6 rule. Now see, the pleading is there in order 6, so we should begin from here. अभी मैं सारे rules आपको नहीं बताऊंगा, मैं आपको बहुत basic बात बता रहा हूँ. Order 6 rule 1 says pleading shall mean plaint or written statement. Pleading to state material facts, not evidence. See, Order 6 rule 2 I am reading. You can see your barract as well. Every pleading shall contain only a statement in concise form of the material facts on which party pleading relies for its claim or defense, as the case may be, but not the evidence by which they are to be proved. So, we are not here to prove the evidence. And here at this point of time, I must tell you, there is difference in writing of a plaint and there is difference in writing of a petition. If you file a petition under Article 226 of Constitution, then you are required to write their facts, you are required to write the evidence, you are required to state the law as well. So, before High Court, if you want to file a writ petition under Article 226, you will say the facts, you will state the facts, you will also state the evidence and you will also write the law. But here in writing of the plaint, there is no requirement of writing of this law and evidence. You are required to write material facts only. Material facts only. Material facts only. So it says, Order 6 Rule 2, every pleading shall contain only a statement in concise form of material facts on which the party pleading relies for his claim or defense, as the case may be, but not the evidence. Every pleading shall when necessary be divided into paragraphs. तो मैंने भी लिख दिया Order 6 Rule 2. अब आप घर पे जाके इसी को लिखते रहोगे. Now, then it says, so far as it is numbered consecutively, each allegation convenient contained in, so each allegation into different paragraph. All necessary particulars to be stated, dates, sums, numbers shall be expressed in pleading in figures as well as words. So that is very, very important. Dates, sums and numbers, just to bring clarity, shall be stated in figures as well as in words. बहुत बेसिक रूल बता रहे हैं, आप वर्ड्स में भी लिखेंगे फिगर्स में भी लिखेंगे. जैसे लिखा 2 जनवरी 2018. अब इसी को लिखेंगे 2 जनवरी year 2018. So it should be written in digits or sums, or it should be written in figures as well as in words. Form is given in Appendix A, where there are applicable forms of the like character as nearly as may be shall be used for all pleadings. So form is not a material fact. Particulars to be given when necessary. Like now there was misrepresentation, fraud. So suppose if there is a contract and you allege that the contract was entered into by fraud, by misrepresentation, and you seek a refund of money on that basis. Suppose this is so. You claim a refund of money, there is a voidable contract in which you have entered into due to fraud, due to misrepresentation. Then you will mention this particular and necessary fact, and you have to mention that fraud has been committed or misrepresentation has been committed. So that is what is written in Rule 4. It says, in all cases in which party pleading relies on if you are relying on misrepresentation, you are seeking, आपने पढ़ा होगा ना voidable contract, Section 19 of Indian Contract Act 1872. You must have read that, can you forgive me for my mistake? So C for coercion, U for undue influence, coercion is in 15, undue influence is in 16, forgive, F for fraud, that is 17, me for my mistake, so 18 is misrepresentation. So on the ground of coercion, undue influence, fraud and misrepresentation, you can seek remedy of avoidance of contract. And on the ground of mistake, you can even seek the remedy of avoiding the contract because it is void agreement, Section 20. Both parties of contract are under mistake of fact, then this is void agreement. So that is the relief which you can claim. So if there is fraud or undue influence or coercion, so you can now state that fact into your particular suppliant. That is how the court will give you relief and what basis court will give you relief. Is this clear? Is this all right? So this is what is basic rule in pleadings. Now, if you see that in drafting of plaint, what are the contents of plaint? क्या लिखेंगे आप plaint में? Now, then the pleadings has to be signed and verified. That is also very important. If you see, every pleading has to be signed and verified. I'll come with the format of plaint also, but just you understand the basic law first. Format बाद में आएंगे आप लोग. Pleading to be signed and verified also. Verification. Can you see this rule 14? Order 6. And to be verified. अभी बहुत बेसिक चीजें समझो. Don't run away. So verified and signed. अब देखो क्या लिखा है इसमें. Every pleading shall be signed by the party and his pleader, provided that where a party pleading is by reason of absence or for good cause unable to sign, it may be signed by any person duly authorized by him to sign for same or to sue or defend on his behalf. Is this clear? So if this is your complaint is pleading of plaintiff, so plaintiff will sign it. And after plaintiff's signature, the lawyer will also sign it. So that is what is written by the party and pleader. So signed by party and pleader. अब कोई हम आपके पास फॉर्मेट लेके आएंगे और उसको हम लोग फिर से करेंगे और हम दिखाएंगे आपको कैसे कैसे हम साइन कर रहे हैं. Is this clear? That we'll do it. Don't worry. लिखा है आपके बेयर एक्ट में भी है, कुछ करने की ज्यादा जरूरत नहीं है. मैं आपको एक फॉर्मेट भी दे दूंगा ऐप में, डोंट वरी. बट अभी हम बेसिक बातें बता रहे हैं. अभी हम आपको प्लेंट ड्राफ्टिंग का बेसिक रूल्स बता रहे हैं. हम प्लेंट को ड्राफ्ट करेंगे अगली क्लास में, देन आई विल ब्रिंग दैट, डोंट वरी. 4-5 फॉर्म हम अपनी से बना के दे देंगे आपको, दो इट इज देयर इन योर बेयर एक्ट. दैट इज नॉट ए ग्रेट थिंग. वेरिफिकेशन, रूल 15. Save as otherwise provided by any law for the timing in force. Every pleading shall be verified at the put by the party or by any one of the parties. So you have to verify that all those averments, all those facts are correct to my knowledge. The person verifying shall specify reference to numbered paragraph. Para number 1, 2, 3 shall be verified of his own knowledge, because he knows the fact better. He entered into contract. He gave him that much money. He signed the contract. Contract was, he knows better. And what he verified upon information received and believed to be. So upon information, like his lawyer says that this court will have jurisdiction, it is not barred by limitation, you can seek this relief, this is the cause of action. Now, so that his lawyer knows, he doesn't know law. So he will verify on the basis of information received and believed it to be true. Person making it shall state the date on which and place at which it was signed. The person verifying the pleading shall also furnish an affidavit in support of his pleading. So affidavit has to be also given. Is this clear? So pleading to be signed by and verified by party on his knowledge, because he knows on his own knowledge. For example, para 1, 2, 3, I'll show you. 4, 5 are true to my knowledge. Signed. Something like that. And then बहुत आराम से चलो. Some people may be in hurry, but I give them a special lesson that please don't be in hurry, for God's sake. For God's sake. If you want to learn it. And I will make you learn it. It's very simple. Then verification shall be signed by the person making it and shall state the date. All right. And what he verified upon information. Again here, para, now 6, 7 and 8. He verified upon information received. Again, so you sign. So it is verification because he does not know. He has received information from the other party and believes it to be true. He is a lawyer. But it is his own knowledge because he knows the fact better. Now then see, अभी जितना आपको मैं बता रहा हूं आप उतना ही पढ़ना, आप आगे आगे मत भागना. कुछ लोग आगे आगे भागना चाहते. सो इट इज हम्बल रिक्वेस्ट, डोंट रन अवे. मैं सब पे आऊंगा धीरे धीरे, बट एक बार में बम्बार्डमेंट नो, प्लीज नो. Order 7. So now when you come to order 7, particulars to be contained in plaint, very important. Particulars to be contained in plaint, contents of plaint. कुछ नहीं करना, आपको ऑर्डर 7 रूल 1 देखो पहले. Then we'll see one by one. अब देखो कितना आसान है. It's very easy to understand here. First of all, the court will come in picture. कोर्ट में ही तो फाइल करोगे ना, इसको कहाँ करोगे? प्लेंट में. कहाँ ला लोगे? ये कोर्ट कौन बताएगा? कौन से कोर्ट को जाएगा? ये वकील बताएगा. कोर्ट. Who will go to the court? Plaintiff. Against whom he will go? Defendant. Is this clear? Whether any party is minor or unsound, with what you will go? Cause of action. Then you will say that court has jurisdiction. That is how court will come in picture. Then you will say that I seek this relief. Then you will say that there is set off in this case. Set off, that is setting off mutual debts. अब देखो इसको, आप देखो now order 7 rule 1 I am looking into. You just see the bare act. The plaint shall contain the following particular: the name of the court, so this is one. The name, description and place in residence of plaintiff. Name, description. How will you identify the plaintiff? So name, description, residence. Name, description and place of residence of defendant so far as they can be ascertained. Alright, A, B, C. Then C, D. Where the plaintiff or defendant is a minor or unsound, a statement to that effect. So this is number 4. The fact constituting cause of action, this is number 5. The fact showing the court has jurisdiction, number 6. The relief which the plaintiff claims, number 7. Where the set-up or relinquishment of portion of claim or amount so allowed or relinquished, this is number 8. And a statement of the value of subject matter for the purpose of jurisdiction and court fees. So after set-off, what is there? So begin from here: court, plaintiff, defendant, if there is minor or unsound, so a statement to that effect, cause of action, jurisdiction. This is all common sense. Then you seek relief. Then there is set-off. Set-off means setting off mutual debts. I have taken 500 rupees from you and you have taken 200 rupees from me. So there will be set-off of 500 and 200, so only 300 is rest. Relinquishment, that is where you relinquish, you leave certain claims. Set-off or relinquishment. And last but not the least, valuation. Valuation for jurisdiction as well as court fees. Valuation for jurisdiction, because pecuniary jurisdiction will be decided on this basis. Pecuniary means money related jurisdiction. And court fees also. This is civil suit, so court fee has to be paid. This is not criminal suit, it is not a public wrong, so court suit is required. So these are the contents of plaint. इसी के बेसिस पर हम प्लेंट लिखेंगे. बट आप पहले बेसिक रूल्स को पढ़ना, अभी आप प्लेंट को लिखना मत. देखो हर चीज का ना एक प्रोसेस है, स्टेप है. आप जैसे ही इसको जंप करोगे ना, आप प्रॉब्लम में रहोगे. मैं प्रॉब्लम में नहीं रहूंगा, मैंने सीपीसी कई बार पढ़ा दिया है. तो यदि आपको कोई भ्रम हो कि मेरे को इससे कोई प्रॉब्लम, तो आप अपनी भ्रम को दूर कर लीजिए. आई हैव नो इश्यू, बट यू विल हैव ग्रेट इश्यू. Maybe 1-2 may not like my idea, but 99.99% people will agree, students will agree that whatever I am saying, that has some logic, that you cannot jump, don't jump always. अब देखो, this is the basic. अब देखो हमें contents of plaint याद करने में कुछ नहीं करना, it's effortless. Plaint कहाँ लाओगे? कोर्ट में. कौन लाएगा? plaintiff. किसके खिलाफ? defendant. Are they minor or unsound? We have read that in order 32 if you remember correctly. So statement to that effect. 4th. What you are seeking there? Cause of action. Cause of action. भाई हम आए हैं आपके पास, I have this matter before you. There is cause in my case, that is why I have come. Why you have come to me? Because you have jurisdiction, my lordship. So what I can do for you? A relief. But this is the setup or relinquishment. I am willing to leave this claim. My claim is 11,000 rupees. But you have jurisdiction till 10,000 rupees. So I am willing to relinquish my claim of 1,000. I want to seek relief from you, because if I go to higher court, I will waste my 11,000 rupees in fees, etc. So I want to claim it here. This is the prerogative of the plaintiff to claim less. He cannot claim more, but he can claim always less. He can claim less. So he has come to this court and court has jurisdiction in 10,000, that is pecuniary jurisdiction. So he can relinquish his claim of 1,000. So he can leave his claim. Relinquishment means leaving. Relinquishment, chhod dena. Set up, I said mutual adjustment of debts. I have 500 rupees due on you and you have 200 rupees due on me. So 500 and 200 are adjusted, so I will claim 300 rupees from you. This is what is set off. We have set off our debts. Set off. SET set, OFF off. So this I will write. So how I started, I said court, plaintiff, defendant, if any one of them is minor unsound, then the statement to that effect, then cause of action, then jurisdiction. Then you give me relief. And in this relief I am relinquishing this claim, 8. And then the last valuation for jurisdiction and court fees. So 9 things. अब इसको याद करने में कोई कठिनाई. This is what will come in format. पहले कोर्ट का नाम लिखोगे, फिर पार्ट, बट मैं अभी फॉर्मेट में आपको नहीं ले जाऊंगा. मैं मेरे को समझ में आती है. पहले आप बातों को समझो, हम फॉर्मेट में भी आपको ले जाएंगे, डोंट वरी. पहले ग्रामर पढ़ रहे, फिर यूसेज को देखेंगे. नाउ ऑर्डर 7, पर ये बहुत आसान है ना. डोंट मेक इट कॉम्प्लिकेटेड. कुछ लोग इसको कॉम्प्लिकेटेड बनाने का सोचेंगे, बट कॉम्प्लिकेट नहीं करना है. आप बेयर एक्ट को पढ़िएगा, आपको बहुत सारे ज्ञान मिलेंगे इसमें. ना देन ऑर्डर 7 रूल 2. Now, if I ask you a very simple question, law is common sense. If it is a claim of money, if it is money suit, will you not mention the amount of money? Kitna paisa? How much money you have due? How much money you want to claim? So, rule 2 says, where the plaintiff seeks recovery of money, plaintiff shall state the precise amount claimed. So, if money, then amount. फिर से आएंगे इन सब बातों पर, बट अभी अब ध्यान से देखो. इफ योर क्लेम इज रिलेटेड टू इमूवेबल प्रॉपर्टी, तो बड़ा आसान है ये सब. आप नहीं करोगे ना तो आपको लगेगा चीजें कठिन है, बट है चीजें बड़ी आसान. द थिंग्स आर वेरी इजी. वी कैन मेक इट डिफिकल्ट. हम ना अपनी गलत आदतों से, प्रक्रियाओं से इन चीजों को कठिन बना सकते हैं. दैट कॉम्पिटेंस वी हैव. But the things are very easy. Things are very, very easy. मैंने ऑर्डर 7 की सब बातों को एक एक शब्दों में लिखा. आप भी लिखो. रूल 3, immovable property. एक एक one word I will tell you. Rule 4, representatives. If there is any representative, mention it. If you are a representative, mention it. See, when plaintiff sues as a representative, if you are suing as a representative, mention it. Defendant's interest and liability to be shown. How he is liable. Rule 6, exemption from limitation. Rule 7, is specific. Now it says right to be specifically, relief to be specifically, specific statement of relief. Don't give vague statement. What kind of relief you seek? Like now, you have gone for a specific performance of the contract, but if there is no possibility of a specific performance, then what we can do? What we can do? Now then we can ask for alternative relief, that is damages, etc., or that is refund of money. So always claim is specifically. Is this clear? Separate grounds. Relief founded on separate grounds. Several distinct claim or causes of action, then they shall be stated as far as may be separately and distinctively. Rule 8. Now, this is just beginning. I'm just talking of drafting of plaint, so I am concentrating on rules related to that. Right now I am not discussing admission of plaint and rejection of plaint, that will come later on. I hope you have understood this much. Nothing great in it, it's very, very simple. If you do not understand this, then we will make you understand again. अब आप मुझे बता दो कि आपको इसमें कोई समस्या है तो। देखो ये क्लास ना लंबी होती है, इसको ना बड़े धैर्य से ध्यान से सुनना है, समझना है, एक एक चीज पे चर्चा करेंगे, हम आपको फॉर्मेट भी देंगे, हम आपको सब बताएंगे, हम आपको आपके साथ हम डिस्कस भी करेंगे, प्लेंट को ड्राफ्ट करेंगे। अभी अगली क्लास में ना हम ड्राफ्ट करेंगे प्लेंट को, आप और हम दोनों मिलके करेंगे। आप हम दोनों मिलके ड्राफ्ट करेंगे प्लेंट को, डोंट वरी। बट पहले आप ऑर्डर 6 का जितना रूल मैंने बताया और ऑर्डर 7 का जितना रूल बताया, दैट मच यू राइट डाउन एंड रादर रीड इट केयरफुली and just write it in brief so that you can have that in memory. Basic rules are clear to you. If you are clear about basic rules, then we will move further. भाई आपको कंटेंट्स ऑफ प्लेंट समझ में आया कि नहीं, पहले तो ये बताओ। अब देखो जहां अब तुमसे पूछे, देखो भाई हमने ऑर्डर 7 रूल 3 में लिखा इमूवेबल प्रॉपर्टी। So if you do not give me correct picture of immovable property, how will we decide the case and how will we identify? तो खाता number, खसरा number, now तौजी number, whatever. It is essential part of the plaint. You are required to tell the court exactly where it is, what property it is. Otherwise, we will be having wrong determination. So where subject matter is immovable property, description of property sufficient to be identifiable is very, very important. And if you do not do it, plaint will be rejected because it is essential part of the suit. एक बार सुप्रीम कोर्ट में सवाल भी उठा था कि मान लो कोर्ट का नाम गलत हो जाए या कोई सेक्शन गलत लिख जाए तो क्या उसके कारण भी प्लेंट रिजेक्ट हो जाएगा? नहीं, दे आर नॉट एसेंशियल पार्ट ऑफ द सूट. But if your property description is written wrongly, it is. अब मैं आपसे ये भी बताऊंगा what are essential part of suit and what are not. बट जितना बताया उतने पे पहले कंसंट्रेट करो. मैंने बताया कि सूट की प्रॉपर्टी पे there has to be exact description. You cannot get a relief if you do not mention the exact description of property. Exact description of suit property is must. अब exemption from limitation में हमने लिखा. अब limitation में, now whenever we institute a suit, then we ask for the court that I am exempted from limitation on this ground. Limitation Act comes into picture. But if you read Limitation Act and if it is not pleaded, no, even then court is required to see this whether it is. The plaint shall show ground upon which exemption is claimed. Even Limitation Act says that it is the duty of court to say whether suit is barred by limitation or not. So it is the duty of court to see this. Section 3 of Limitation Act. Order 7 Rule 4. हम लोग तो बार बार पढ़ेंगे, अभी तो जस्ट मैंने बिगन किया है. आप देखिए ऑर्डर 7, व्हेन प्लेंटिफ सूज एज व्हेन प्लेंटिफ सूज, आप यदि रिप्रेजेंटेटिव कैरेक्टर में सूट फाइल कर रहे हैं तो उसको भी मेंशन करना है कि आप क्या रिप्रेजेंटेटिव हैं या आप ही प्लेंटिफ हैं, ओरिजिनल प्लेंटिफ आप ही या प्लेंटिफ इन रिप्रेजेंटेटिव कैरेक्टर में. अभी इस पे चर्चा आपको और करनी होगी ना. रिप्रेजेंटेटिव सूट भी फाइल करते हैं, दैट्स ए डिफरेंट मैटर ऑल टुगेदर. सपोज मेरे पिताजी का मैटर और मैं जा रहा हूं तो मैं तो रिप्रेजेंटेटिव ही हूं ना. तो दैट आई हैव टू मेंशन this property was bought by my father and now I am his successor, or now I am his representative and I am coming in that capacity. So this is how it is done. Any other question please? आपको अभी बस मोटी मोटी चीजें ध्यान करनी है, मोटी मोटी चीजें देखनी है. बहुत छोटी छोटी चीजों पे अभी हम नहीं हैं. हम अभी मैक्रो लेवल डिस्कशन कर रहे हैं, माइक्रो लेवल पे भी आते हैं, थोड़ा सा और समय लेंगे. देखो वेल बिगन इज हाफ डन. मैं बार बार आपसे कह रहा हूं कि इफ यू वांट टू अंडरस्टैंड सीपीसी, यू प्लीज बिलीव मी, you can understand it and we'll solve all question in this class. Take my promise. You will solve, I will solve. We will solve it together. But don't discard me, don't take me as for an element. Whatever I am telling you, my dear friend, it is a suggestion by a senior student. So please believe me, it's for your betterment. I am of clear heart, I am of clear mind that if you and me can put our efforts together in synchronized manner, you are bound to succeed. Just you have to give me little bit liberty. You have to give me little bit liberty to act fairly and patiently. Is this clear, my dear friends? Any other point which you want to make? Now, a very important announcement. So, now there is Dasara. See, we have a long class. We have whole year classes. So, we take sometimes little bit break. During Diwali also you will have break. I hope from 1 to 7. It is a necessary break, every year it happens. So don't take it that way that it is you who are suffering or me suffering. No, nothing like that. We have necessary break in Diwali every year. So this year also you will have break from 1 to 7. And in Dasara you will have 3-4 days. No, 3 days I think. 14, 15, 16th you have break. 14, 15, 16th. 14th, 15th, 16th Dasara there will be break. And I think it's better. You can have little bit exercise with CPC. Don't take it lightly. If you have break, it's better. You can work wonderfully. And those people who are appearing in Haryana and Rajasthan, they can prepare well. I have told them the basic points. So you can do it. So I said, and tomorrow you have this English and GK class, my dear friends. All new students are welcome. Order 6, Rule 6 with Order 7, Rule 1. We can read all things. Order 6 and 7 has to be read together. Order 6 and 7 has to be read together for proper drafting of plant. Now, for proper drafting of plant, you have to read them all together. Distinctly specified in pleading by pleading. Yes, आप लिखो. ये order 7(1) के साथ क्या? ये तो है ही, तो common sense है ना कि any condition, precedent, performance or occurrence shall be distinctly specified in his pleading by the plaintiff. Yes, 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 yes. Yes, Mr. Puspak, yes. Now, I don't know whether your question is in a particular context, but generally saying yes, generally saying yes. So I said you will have, now there will be specific notification in your group when there is break, but I have given you preliminary information that in Diwali you will have definitely break. दिवाली में तो डेफिनेट ब्रेक है. रिगार्डिंग दशहरा दे विल नोटिफाई यू. I think 14, 15, 16 there is break. 18th I will have class with you. Tomorrow you have English GK class. Is this all right? Because English GK is equally important. So new people will have better time because they will be now attending that class first time. So you please enjoy that class as well. Be cool, calm, considerate. Please believe me, I am your guardian, I am your friend, I am your well-wisher, my dear friend. So don't disappoint me, don't do anything in the class which disappoints me. I am speaking from my pure heart that I will be serving you as much as I can. I will be giving you many assignments, I will be solving those questions. अभी बहुत कुछ करेंगे इस क्लास में, बहुत केस डिस्कस करना है, हम प्रिपरेशन के साथ आएंगे, आप जल्दीबाजी मत रहो. I will discuss cases with facts. I will tell you how to do this plain drafting and written statement, judgment writing. मैं सब बताऊंगा आपको, बट थोड़ा सा have patience. We will solve all objective, subjective questions. सब करेंगे दोस्त, सब करेंगे. आपको अधूरा नहीं छोड़ के जाएंगे. सीपीसी बहुत अच्छे से पढ़ाना है मुझे, इसीलिए मैं बहुत आराम से पढ़ा रहा हूं. प्लीज बिलीव मी. Oh, वाह वाह जी दिव्यांश महाजन जी. व्हाट इज द पर्पस ऑफ मेंशनिंग डेट्स एंड सम्स इन वर्ड्स? भाई इससे क्लैरिटी आती है. सृष्टि सिंगला बहुत सही कहा. दिव्यांश महाजन जी चाय पी रहे थे उस समय, लग रहा है मुझे सुन नहीं रहे थे मेरे को. Yes, thank you very much. God bless you all. Great. I want this family to be flourishing family. I want this family to be now happy family. I want this family to be confident family. I want this family to be real family. I want you all to be happy. I want you all to be cool, calm, collected, patient. हमने आपको बताई ना कि क्रिकेटर हर बॉल को नहीं खेल पाता है, तो डोंट वरी. एक आध चीज छूट गया, परेशान मत हो. फिर से मैं अभी 10 बार पढ़ाऊंगा प्लेन्ड ड्राफ्टिंग आपको. आप आज ही सारे समस्या का समाधान नहीं कर लोगे. You cannot solve all questions today. It will take time. Yes. Happy Dasara. I am going to see my mother also, because she doesn't live here, she lives in village, so I am going to see her also. So that will be really a great thing for me. I wish you the same, and I hope that you also do the same. Please meet your family members, friends. Please enjoy your time, be happy, and don't be in hurry. We'll be successful. Those who are appearing in Haryana and Rajasthan, please make your routine, because I think Haryana is going to be held on, as I have heard, 13th November, and Rajasthan on 28th November, I hope. No? So please be careful, be cool, calm, patient, have your time limit. Prepare your examination well. You take 4 days time, 3 days time. You give 3 days, 3 days, CRPC, CPC, Constitution, 3 days each. IPC, contract, 2 days each, something like that. You make routine of 20 days or 25 days for Rajasthan, because you do not have much time, only 1 month time. And solve questions of previous years and solve questions of other state also. That is going to help you a lot. You solve question, and if you are not able to solve question, then you see the bare act. So this is how you can remember better. भाई वासुदेव कहाँ हैं आप? वेयर आर यू लॉस्ट सर? देखो यही लोग क्लास को खराब कर देते हैं. विल यू टीच सेक्शन 2 अगेन? मैंने सेक्शन 2 पढ़ाया कहाँ है? आप क्लास में ना शुरू से रहते हैं ना. दिस इज योर प्रॉब्लम. I must condemn this behavior. I must condemn this behavior. Please sir, please. I am extremely sorry to condemn this behavior. I have told you section 2 में मैं आपको अंडरस्टैंडिंग दे ही नहीं रहा, अवेयरनेस दे रहा हूं. कितनी बार बताऊंगा एक ही चीज यार? तुम क्लास में शुरू से नहीं रहते और भ्रांतियां दूसरों के लिए भी फैलाते हो. This is really not acceptable. You should be in the class from the very beginning. See, I have to say this all candidly because other will be confused. Section 2 हमने पढ़ाया ही नहीं अभी. You are asking me, will you teach again? I have not taught it even once. I have not taught it even once. मैंने सेक्शन 2 आपको पढ़ाया ही नहीं अभी. डिक्री तो मैं तब पढ़ाऊंगा जब मैं डिक्री में जाऊंगा. आर यू नॉट इन द क्लास? दैट इज माई क्वेश्चन. आई एम आस्किंग यू सर. Vasudev. Now, if you start like now asking such vague things in class, will you teach section 2? मैंने बताया नहीं आपको. आप क्यों परेशान हो? मुझे परेशान होने दो ना. You don't disappoint me by writing like this. I have told you, अभी डिक्री मैं डिक्री की जगह पे पढ़ाऊंगा. जजमेंट जब पहुंचूंगा तब जजमेंट पढ़ाऊंगा. अभी कहां से पढ़ा दूंगा भाई? अभी तुम जजमेंट के स्टेज पे नहीं पहुंचे हो तो तुम जैसे जजमेंट पढ़ दोगे. नहीं, ओके सर, नहीं, दिस इज व्हाट इज रॉन्ग. It means either you are not sincere or I am insincere. Either of one are insincere. मैं ही मान लू मैं insincere हूं तो मुझे इस बात से बड़ा दुख है कि मैं insincere हूं. अरे यार, अजीब अजीब लोग हो आप कभी नहीं सुधरोगे. कोई ना कोई हमेशा ऐसी बातें करता है जो दिल को चुभ जाती है. It's really disheartening. Are you sleeping in the class? इतना अच्छा मैंने बताया. कभी मैं आपको अवेयरनेस दे रहा हूं, अंडरस्टैंडिंग नहीं दे रहा हूं. डिक्री में डिक्री के साथ पढ़ाऊंगा, जजमेंट में जजमेंट की जगह पढ़ाऊंगा. कितनी बार एक ही चीज पूछ लोगे यार? क्लास ध्यान से जो नहीं करता है ना, वो डिस्टर्ब दूसरों को ज्यादा करता है. दिस इज प्रॉब्लम. यू मस्ट बी इन क्लास फ्रॉम द वेरी बिगिनिंग. बाय द वे, थैंक यू वेरी मच. गॉड ब्लेस यू ऑल.